Good afternoon. Good afternoon. Welcome. For those of you who don't know me, I'm Gary Jenkins. I am the Dean and William S. Patty Professor of Law. And we are delighted to have all of you here today for this great occasion, the investiture of Susanna Blumenthal as the William S. Prosser Professor of Law. At the conclusion of the lecture, I hope that you will all join us upstairs, one level, in the Auerbach Commons for a reception of light refreshments. An investiture of a named professorship is especially meaningful in higher education. It acknowledges the highest levels of academic accomplishment in research, in teaching, in public service excellence. It's a time to celebrate the honoree, but also to honor those who make academic excellence possible. In this case, the Prosser Professorship was created to honor a renowned scholar and teacher in the area of torts. William L., or Lloyd, Prosser, authored several editions of Prosser on Torts. It's universally recognized as the leading work on the subject of tort law for a generation. It is still widely used today. Prosser graduated from our law school in 1928 and joined the faculty a year later. He was a beloved teacher, and he actually wrote his first edition of the acclaimed book while on our faculty for 13 years. Professor Prosser left the university for a position in the Roosevelt administration, returned to private practice for 4 years, taught at Harvard Law School for 1 year prior to his appointment as dean, and a professor at the University of California at Berkeley, a position he held for 13 years. He finally concluded his career at the University of California at Hastings as a member of their faculty. This professorship was established in 1996, so nearly 25 years ago, to encourage and enhance scholarship of the law school. It is my pleasure to formally install my terrific colleague, Susanna L. Blumenthal. The L isn't for Lloyd, is it? Like Prosser? Okay, I didn't think so. Professor Blumenthal received her bachelor's in government from Harvard College, her JD from Yale Law School, and a PhD in history from Yale. Following law school, she clerked for Judge Kimba Wood of the Southern District of New York. She began her teaching career in 2000, joined the University of Minnesota in 2007. She teaches courses in criminal law and American legal history. She also co-directs our highly respected program on law and history. She also holds a joint appointment with the history department within the College of Liberal Arts. Her deep and penetrating scholarship focuses on the historical relationship between law and the human sciences. She is the author of numerous essays and law review articles appearing in the Harvard Law Review, the UCLA Law Review, Law and History Review, and many, many others. Her book, Law and the Modern Mind, Consciousness and Responsibility in American Legal Culture, was published by Harvard University Press in 2016. The book received rave reviews and 2 major prizes: the Sherion Book Prize from the International Society for the History of Behavioral and Social Sciences, and the highly prestigious Merrill Curti Award from the Organization of American Historians. Today, we will all have the benefit of Professor Blumenthal's knowledge and insight as she gives the William L. Prosser Professorship in Law Appointment Lecture entitled The Apprehension of Fraud, Policing Deception in Modern America. I'm going to present Professor Blumenthal with the clock and the representation of her professorship. We need something tangible to hand out of these things. So that's what we do. Please join me in congratulating Professor Susanna Blumenthal.
Thank you. Good afternoon. Without question, the best part of giving a lecture like this is getting the chance to express my appreciation to many people, so many people who've made this day possible. First and foremost, I want to thank my dean, Gary Jenkins, and my extraordinary colleagues and students here at the law school. I'm grateful beyond words for all the ways and means that they inspire and support me, daily reminding me how lucky I am to have this job. I also want to express my appreciation to Elaine Tyler-May and my colleagues in the Department of History, as well as my students in the Department of History, who have also enriched my life and scholarship in more ways than I can count. In addition, I want to acknowledge the contributions to my intellectual life provided by the staff of our law library. Under the direction of the amazing Joan Howland, I'm extremely fortunate to be the beneficiary of the extraordinary research skills of Connie Lenz, Scott Dewey, Vic Garces, and especially for purposes of this talk today, I want to thank Ryan Greenwood and David Zofke Jordan, who many of you know, I think just he's a magician. He finds sources I didn't know existed, and this library has supported my work in so many ways. It wouldn't be possible for me to do what I do without that support. I'm equally fortunate to get to work with Deanna Mello, whose administrative assistance is simply stellar, and whose wit and wisdom are really even more indispensable. I would also like to add a word of thanks to our event manager, Laura Walton, who I'm not sure she's actually in the room at the moment, but she has done so much to make this lecture possible, and she makes all sorts of happenings happen in this law school every day. Finally, there is my family, without whose love and support, none of this would be possible. From near and far, it means the world to be able to share this day with them. It is to my parents that I owe the deepest debt of all. And though the loss of my father in the past year makes this occasion bittersweet for me, I want to dedicate what I have to say today to them. So as I turn to the subject of my talk, it seems important to begin by addressing the elephant in the room. Yes, this chair lecture does fall on April 1st. And yes, that is inauspicious to say the very least. As you may already know, this folk holiday has long marked the transition from winter to spring, which is often accompanied by deceptive signs and reversals, a phenomenon that is especially common here in Minnesota, well into April, engendering a healthy appreciation of the absurd. Insofar as April 1st is the day when fiction can be fact and falsehoods true, it connects not only to the title of my lecture, The Apprehension of Fraud, but also, as it turns out, to the namesake of this lecture, William Prosser. For as it turns out, Professor Prosser was famous not only for his scholarship on torts, as Dean Jenkins has told us, which of course encompasses fraud, but also for his practical jokes and what his biographers describe as his rather unique sense of humor. His body of work, which I'll put up here, and does include the Handbook of Torts, again, that Dean Jenkins mentioned, but it also includes a number of other less renowned pieces of work. This is The Judicial Humorist. It was published in 1952, in which he describes in the preface some 40 occasions on which justice has descended from her pedestal, laid aside the bandage, and done a bubble dance with the scales. which I would submit can be read as evidence of the historicity of humor. This is a bubble dance, for those of you who don't know what that is. I didn't. Digging a bit deeper into the archives, it emerges that Professor Prosser was actually also a very seriously talented playwright, if somewhat frustrated ultimately in that pursuit. Because while it remained kind of an avocation for him over the course of his long and productive career as a law professor and dean, it was not sort of something that he felt he could sort of make a living from doing. That said, he did some of these plays were indeed performed, one entitled Free Speech, which was, quote, a farce on the present Russian situation, which was first staged at Harvard in 1918 while he was still an undergraduate. His talent at the time was recognized by George Pierce Baker, an eminent member of the Harvard English department, who invited the young William to join his famous playwriting workshop in his senior year, putting him in the company of some of the greatest names in American letters of the time. This is Thomas Wolfe, Maureen Dallas Watkins, and Eugene O'Neill. As heady as this environment was, the young William ultimately doubted whether or not this could actually be a career for him. And he found it quite difficult. He went through some degree of vocational sort of anxiety for several years. And there's lots of letters between him and his father about what he was going to do with his life. At one point, he actually sent his father, I think, to annoy him. His father was actually the father of vocational education. He was the first principal of the Dunwoody School here in Minneapolis. And so he's writing to his father, who would like him to sort of get a job. And he sends him a mock resume that really was a list of job disqualifications, including such lines as probably distorted idea of finance and economics obtained from college course, likely to blow up under prolonged irritation and inclined to be too critical of superiors, gets grouchy when lonesome, eats onions occasionally. So he was torpedoing himself from an early age. But eventually and happily, he finally decided on law school. In 1920, he started at Harvard, dropped out after his first year, spent some time working on the railroad, literally, before deciding to go back and finish his education here at the University of Minnesota, where he graduated first in his class in 1928. He then spent several years in practice in downtown Minneapolis and was sort of playing a back and forth game with the dean. Dean Fraser at the time was trying to get him to join the faculty, and he hemmed and hawed about it. He, in his letters again, is ambivalent because he thinks he's too young to take the veil. He also thinks a life in legal academia might be too cloistered for him, too detached from the real world. Once on the faculty, he continues to sort of question his decision. He notes that pressure here is unknown. People are very relaxed and spend lots of time watching baseball games and football games. And the main challenge is to stay, quote, 10 days ahead of the game. Some of us may know that dance. In the courses that he was taking, he also sort of complained about long faculty meetings, as you might imagine. In any event, he, after not very long, reconciled himself very happily to life in the law and law school more particularly. And as I've already noted, he really did write the book on tort law in the 20th century, and was a very, very highly regarded scholar and teacher. So it is, of course, needless to say, a huge honor to have this name attached to mine, or to take on this chair. But I do want to add a few more things about his literary proclivities because they have some pertinence to what I'll be talking about today. During the remainder of his career out west, first at Berkeley and then at Hastings, he continued to channel his intellectual energies mostly in the direction of legal doctrinal matters, serving, it's important to add, as the official reporter of the Second Restatement of Torts. But he also was the official or unofficial lyricist of the AALS, and continued to sort of channel some of his creative energies in that direction. There was lyrics that they sang apparently at these AALS meetings. Just to give you an example, there was a song called "Why Can't Professors," which was sung to the tune of "Why Can't a Woman from My Fair Lady." I commend this entire volume to your attention. No, I don't. While this travesty of the work of George Bernard Shaw might be taken to demonstrate why those who teach law should not try to do joke telling and songwriting, etc. This brief biographical sketch of the life and times of William Prosser provides today a point of departure for me and for the thinking I want to do today about law's relation to theater and more broadly to the realm of fiction, to the realm of make-believe. The historical analysis I will offer draws from a book I'm in the midst of writing, which is also the title for this lecture, The Apprehension of Fraud, Policing Deception in Modern America. In my lecture today, I will begin by providing an overview of this project and its aims before turning to a single and singular forgery trial of a Wall Street broker by the name of Charles B. Huntington. This trial was in 1857, and it involved a plea of insanity and dueling interpretations of William Shakespeare's Hamlet, which will be taken to show that the prosecution of fraud is a funny business. I first encountered this Wall Street broker while working on my first book, Law and the Modern Mind, which explored the way that law reckoned with cases of mental incapacity on the understudied civil side of the docket. Due to the scope of that project, the Huntington forgery trial ended up on the cutting room floor. But the story of his apprehension as a criminal stayed with me because it did not fit easily into the prevailing historical accounts of the phenomenon of fraud in American culture. According to these accounts, 19th century America was the era of the confidence man, the age of Barnum, a time and place when humbug was rife and law enforcers looked the other way, reconciling themselves to the fact that fraud was simply the price to be paid for living in a burgeoning capitalist society. Now, in the scholarship on fraud, most historians have taken their cue from the work of Morton Horowitz in his well-known but much criticized The Transformation of American Law, premising their accounts on his rendering of the law of fraud in the period from the Revolution to the Civil War. Horowitz's transformation presented the law in socioeconomic terms, arguing that it enabled the development of industrial capitalism by shedding equitable doctrines of fairness and enforcing the will of the parties in ways that benefited entrepreneurs at the expense of the working classes. Within this legal scheme of things, fraud narrowed in meaning and became prohibitively difficult to prove in all but the most obvious cases. In other words, on his account, caveat emptor was the operative rule, which meant that victims of fraud usually had only themselves to blame. While enormously influential, the book that Horowitz wrote inspired all manner of correctives, not least because its author did not attend to the role of gender or race, nor did he speak to the issue of slavery as he charted the triumph of contract. This revisionist writing has complicated his portrait of market individualism, with the most recent and important work integrating the history of the household, both slave and free, and that of banking, insurance, and bankruptcy, which reveals the extent to which the 19th century was a time and a place in which American citizens were enmeshed in a moral economy, in which an individual's personal character, in particular his creditworthiness in a psychological as well as a financial sense, continued to count in large amounts, though this attribute proved as difficult to gauge as it was important for all to determine. This, in turn, gave rise to widespread worries about deception and elaborate efforts to guard against being duped. Yet, strangely enough, the story Horowitz told about the law of fraud has had considerable staying power. The newest entries into the historiography of American capitalism, I'm thinking here in particular of Stephen Mims' A Nation of Counterfeiters, and Edward Ballason's Fraud, An American History from Barnum to Madoff. These works more or less follow Horowitz's account, and they tend to sort of summon up Herman Melville's 1857 novel Confidence Man as Exhibit A for the extent to which 19th century American law basically enabled fraud, encouraging the growth of a population of pretenders who made humbug essentially a way of life. So after spending years of study in my first book of what is described as the jurisprudence of insanity in the 19th century, which we can take as an oxymoron, but also an important category of 19th century medical legal discourse, as doctors and lawyers came together to think about the mind and the implications for what they were finding to be true about the mind for purposes of everyday adjudication. The more that I looked into that literature and studied it for purposes of my first book, it became clear to me that when they were litigating questions of mental capacity in the 19th century, lawyers, to just cover their bases, would often bring in tandem also claims of fraud and a doctrine called undue influence, which is kind of a very Victorian way of talking about deception without actually talking about it. You sort of basically overcome by someone else's influence, regardless of whether or not they intended to defraud you. But these two different doctrines were very much other ways of sort of making claims about weakness that might not have satisfied the legal standard of insanity. And so there was just an enormous amount of litigation in that realm that I became very interested in as I was working on my first book. And it was also very clear that people were worried constantly in these cases involving insanity about feigned insanity. So there was that kind of fraud going on as well in the courtroom. And all of this made me think that the existing accounts of the history of fraud in 19th century America were dramatically understating the extent to which the legal system was involved in regulating or at least reckoning with fraud. Indeed, these dizzying capacity contests I looked at ultimately raised some really deep questions, not only about whether we can trust each other, but really ultimately whether we can even trust our own mental faculties, whether we can really sort of trust what our mind is telling us is real and true about the world. And so they served as ultimately the inspiration as well as a foundation for this current project on the apprehension of fraud, which, in using the word, I use the word apprehension quite advisedly here, both to capture the fact of the worry about fraud and also the ways that the legal system really was actively engaged in prosecution and containment. Now, the question of what constitutes fraud as a matter of law is, as I've found out to both my delight and frustration, depending on the day, is really just as vexing as trying to tackle the problem of insanity in American law, because it's located at the boundaries of legalism. It's both a pervasive problem at law and a ubiquitous term in American in 19th century legal proceedings, and it is also at the same time a foundational keyword for American culture as we've come to know it. For this reason, fraud is genuinely good to think with for legal scholars as well as those who study culture. The book, as I've plotted it out, is intended to explore the ambiguous borderland between legitimate commerce and indictable crime, between ingenious puffery of a salesman and the conniving fraud of a swindler. Here I would like to acknowledge that in this area that I'm studying, there is certainly plenty of evidence that that fraud it was a problem in 19th century America and a tricky terrain. Just to give you some indication here of the problems that people encountered and the reasons why historians have talked about this as a counterfeit nation in the 19th century. Counterfeit currency, this is before we have sort of a national currency for much of the 19th century, certainly in the period that I'm looking at today. There wasn't a sort of a standard currency. Different states had their own currency that they produced, and then there were all sorts of kinds of notes that were being circulated as well. And so the challenge was to find a way of helping people to navigate this tricky terrain through these counterfeit detectors, but it was kind of a losing battle because what the producers of these manuals well knew is that they were also providing evidence that was going to help the would-be or the fraudster to find sort of the new way that he or she needed to print currency to avoid detection. And so you have these constant efforts at updating here. That lookout there is to say, we just had an update, and then one of the things that we've sort of spotted has been found out, and so there's a new version of it that you need to watch out for. So I think there's a well-developed sense that that these manuals are really warning consumers, but also tipping off con men, and that's a problem in and of itself. In addition, there's a kind of sense, again, of the freewheeling nature of this time and place, such that, again, historians have suggested that selling and swindling are really just two sides of the same coin. And again, there is evidence for this proposition in the kinds of books that are published in this period that do celebrate these swindlers as kind of characters that are at least worthy of reading about and perhaps maybe emulating. And the lines are indeed maybe tricky to draw. This is Monroe Edwards, who was one of the most famous forgers before the forger I'll introduce you to today. And this is, of course, P.T. Barnum, whose trials and struggles sort of also fit very comfortably within sort of the idea of the confidence man in the 19th century, even though he denied that he was doing anything wrong. So there is also that kind of evidence of a kind of a difficult distinction to be drawn. And certainly their exploits entertain multitudes. In addition, there is also at least evidence in the popular culture for lampooning of law enforcers as simply ill-equipped or incapable of managing this problem. So that is also evidence to support the idea that law did not effectively apprehend fraud. And in addition, perhaps even more damning is the evidence that we have from, this is a JP manual here. These were distributed to sort of law enforcers on the ground in local localities. This one had to do with the law of evidence. And you'll see in terms of its underwriters here, there are basically purveyors of, here Mrs. E.C. Phelps is purveying a get-rich-quick scheme here that she promises will be very profitable if you send some money her way. In the first instance, and she, as you should sort of be aware, this is no humbug, is something that she advises there in the small print. And yet, all the while, even given this evidence of lots of fraudulent conduct and difficulties apprehending it, it's also interesting to note that a great deal of intellectual energy is being expended in this period, and institutional resources as well as mental efforts to distinguish fraud from humbug, with P.T. Barnum himself participating in this process. Indeed, contrary to prevailing accounts, as I dip into this treatise literature, it becomes very clear to me that what you can see happening doctrinally in the 19th century is actually an expansion of the legal definition of fraud. Contrary to what Horowitz has argued, I think there's considerable evidence for the proposition that fraud as a legal category is widening in this period. There's an 18th century jurist, Lord Hardwicke, who famously sort of describes fraud in the following capacious terms. He says, fraud is infinite. If a court were to lay down rules indicating how far they would go, or to strictly define the species of evidence of it, the jurisdiction would be cramped and perpetually eluded by new schemes, which the fertility of man's invention would contrive. In other words, he was wise to the ways of fraud-feasors, recognizing that they would like nothing half so well for courts to say they would go thus far and no further in his pursuits. So the conclusion that both he and 19th century courts drew from their thinking about fraud and its proper boundaries was they were just not going to tell you what they were. And it's interesting to see the ways in which P.T. Barnum tries to push back against that. He is the one who is trying to provide a more determinate definition of fraud in his Humbugs of the World, and he wants to distinguish it from humbug, which is harmless, entertaining, and maybe even educational by his lights. And so he wants to have a more determinate definition of fraud, and he tries to participate in its containment in a certain way. But 19th century courts generally exhibit their own kind of gamesmanship in resisting definitions in an interesting way, and in a way that I would say is in serious tension with democratic ideals, especially of transparency in lawmaking and the rule of law more generally. This tension is at the heart of the story that the law of the apprehension of fraud will tell. casting the evidentiary net to encompass the records of legislative proceedings, lower courts, police departments, and private detective agencies, and also mining the archive of fiction, the book traces out the ways and means by which norms of truth-telling and fair dealing were articulated and policed over the course of the long 19th century. In doing so, I seek not only to provide a corrective vision, but also to shed light on the historical relationships between law and social trust. In order to illuminate these dynamics, the study has two main parts. In the first part, I look at the rule structures that are in place and evolving over the course of the 19th century. I'm interested in the sort of actual formal legal rules, but also the ways in which other kinds of enforcers are operating and interacting with the legal system. I'm thinking here about the vigilance of private citizens, religious leaders, and journalists, as well as a host of self-policing trade associations. The primary aim in this part is to excavate and analyze the moral taxonomies implied by this set of rules, institutions, and practices, with emphasis placed on the play within the system and the practical problems and ethical quandaries that law enforcers confronted as they attempted to beat the con artist at his own game. The second part of the book then turns to the scene of the courtroom, presenting a series of case studies that reflect widespread cultural anxieties about deception in both the home and the market, focusing in particular on those concerning purloined wills, religious imposture, medical quackery, forged financial instruments, and fraudulent insurance claims. These cases provide a window on the contested middle ground between outright lying and complete candor, illustrating the difficulties entailed in proving the intent to defraud in everyday adjudication. Each trial I show was a credibility contest on multiple levels, an arena within which competing narratives were theatrically presented with insinuations of false witnessing and charges of legal legerdemain freely made by parties, to say nothing of the popular press. The twists and turns of the decisional law record the efforts of 19th century American judges and the other participants in these trials to reconcile the conflicting imperatives of liberty and equality that were built into the doctrines of contractual freedom. Rather than pronouncing a clear doctrine of caveat emptor, their opinions register an abiding concern with imposing order on a boom and bust economy, lest the processes of self-making and money-making become hopelessly confused. In recounting these legal struggles, I aim in this work ultimately to contribute to the scholarship in a couple of distinct respects. In one way, I'm trying to contribute to the history of capitalism literature and the ways in which law and capitalism operated in relationship to each other. I'm interested in the accounts that exist now that say that capitalism took command in the 19th century, but looking at the way in which law, to some extent, was mediating between sort of those who were running businesses and those who were consumers, and understanding the particular ways in which law constructed ideas of fairness in this economy. In approaching this subject of fraud, I also regard fictional literature as an indispensable primary source and apply the tools and techniques of literary analysis to legal discourse as they enable me to more fully reveal the psychic roots and ideological stakes of everyday adjudication. And so I take works like Melville's Confidence Man and use them to sort of illuminate trials and to illuminate and use the trials to illuminate the literature and see both kinds of processes and sites of thinking about fraud as a part and parcel of expressions of deepening doubts about the basis of trust in a society that is built on the shaky foundation of self-sovereignty. To litigate the question of fraud, I ultimately want to suggest is to raise all sorts of deep problems about human subjectivity, agency, and identity, terms which all carry double meaning of both autonomy and dependence in the period under consideration. As these courtroom battles were replayed and editorialized in newspapers and professional journals, they served at once as forms of popular entertainment and critical testing grounds for competing psychological theories, behavioral ideas, and modes of government and conceptions of truth. So with the scene thus set here, I will turn now to the great Huntington forgery case, and that's the way it was widely referred to in the media, which provides an especially rich site for examining the relationship between legality and theatricality. As you will see, it provides a vivid example of the ways adversarial trials perform their truth-finding function in our legal culture, even as they are produced and consumed as performances, ones that are aimed not only to investigate and establish the facts of the matter, but also to dramatize them. So the apprehension of Huntington Charles B. Huntington, by the New York police on October 9th, 1856, on a charge of forgery, quickly became the talk of the town. The initial charge was based on a single note for $6,500, but during the police investigation that followed, more and more spurious paper came to light, rumored to amount to at least $500,000. According to the emerging story, which on most accounts presumed his guilt, Huntington the forger was an amazingly brazen shyster, and his exploits were shocking to those who read them. He was a relative unknown in financial circles until about a year before his arrest. And yet Huntington nonetheless managed to finagle ever larger loans from the most responsible and respectable firms. Offering a combination of forged and genuine notes as collateral, he endeavored to redeem them before their maturity so as to conceal the modus operandi by which he effected his designs. His success was not easily ascribed to skill or circumspection as a financier, however. For many of the forged notes he passed contained signatures that didn't even pretend to be imitations, and he spent the money that he had made living extravagantly in plain sight. Indeed, Huntington was described as the most conspicuous of consumers, famously addicted to the finest cigars, the fastest horses, and the prettiest women that money could buy. Therein lay the puzzle for many newsmen and presumably his readers as well. Why did it take so long for this unabashedly double dealer to be apprehended as such? The perplexity only deepened as it was revealed that Huntington had been indicted 4 years earlier for a similar swindle in upstate New York, one that had received all due publicity at the time, though the charges were ultimately dropped for some sort of unspecified technicality, and he was free to set up his shingle anew in Wall Street. His brush with the law seemed, in fact, to enhance his creditworthiness with the financial world, winning him unlimited confidence with his brother sharpers. In fact, some press accounts fingered his fellow brokers, aka these are sort of note shavers, as willing accomplices, disdainfully observing that it was common practice among members of this codfish aristocracy to deeply discount bills suspected to be forgeries, effectively turning them into usurious transactions, which implicated these victims morally, if not legally, in Huntington's crimes. This is perhaps what deters some of the negotiators from stepping forward, speculated one reporter, although there are doubtless others that are simply just too embarrassed that they were fooled by this guy. And so that's why you have here this line, the shavers are being shaved this time, who are they? Don't all speak at once. They just couldn't get anyone to come forward and admit that they had been part of his class of victims. But ultimately, it appears that there were a sufficient number of victims who did actually come forward, and as a result, the trial was indeed able to go forward, and the first of 27 indictments was set for consideration in late December of 1856. Now, these courtroom proceedings were very highly attended, at least in the first days, but the most audacious form of fraud that was going to be considered was arguably yet to come, as it was perpetrated by the defense attorney, as you'll see very shortly. In this space, in the first instance, the defense team attempted to refocus attention away from the defendant and towards the newspapers. The extensive pretrial publicity meant that the defendant had already been sort of judged guilty by the press, according to the defense counsel, and so they turned voir dire into a major production. They questioned each of the prospective jurors intensively, asking did they believe everything they read in the newspaper, implying that that was inadvisable, if not disqualifying. When they finally did get a jury selected, the district attorney endeavored to refocus attention on the defendant and his misdeeds, deeming this to be a case of public interest and casting the crime of forgery as the worst, the meanest, the most despicable of all commercial lies which a man can tell or which a man can make, a black lie and a white lie at the same time. Waxing hyperbolic about Huntington's most wide-awake and shrewd method of defrauding his fellow brokers, the DA inadvertently aided the defense by depicting his behavior as a sort of moral insanity that seemed to have seized upon him. Without pausing to consider the exculpatory effects of his own portrayal of the prisoner, he allowed his listeners to glimpse the final scene of the immoral drama that was about to be performed before them, where the great commercial detective finally appears on the stage and publicly exposes the full extent of Huntington's frauds, at which point the denouement comes, the wrongdoer is taken into custody and placed behind bars. He says, "You may pile up your bookcases with novels and dramas, but you will never find them as interesting as the transactions that pass before you in this courtroom." He finished with a flourish, adding that it was a small story, but a comprehensive one. For he submitted that the case of Huntington implicated the moral character of this great commercial metropolis, lending credence to the condemnations of sneering strangers who called it the modern Sodom and Gomorrah. Assuming the role of virtue's advocate, showing himself to be a virtuoso in the use of melodramatic conventions in the courtroom, this DA expressed the ardent hope that he was addressing 12 righteous men who would just demonstrate that the city might yet be saved by delivering a guilty verdict. Well, the witnesses for the prosecution did not really live up to their billing. It was not a particularly interesting set of witnesses that they put on, and there was a basic collapse in public curiosity. The tedium basically drove people away, and and there was little doubt in any event from the proof being presented that the defendant was indeed guilty. Meanwhile, the actual victims looked to be sort of basically in on the sort of corruption by virtue of the fact that pretty much everyone on Wall Street was engaging in the sort of active, whenever they got a sort of fraudulent note, it was kind of like playing pot potato, you just move it on to somebody else. And so this is not a good story for anyone involved ultimately, but there was no question that the forgeries were forgeries. For their part, the defendants sort of had a tough road ahead of them, it seemed, going into their part of the trial. They got up, and the defense attorney who gave the opening argument essentially argued that the trial really shouldn't have been dignified with the kind of publicity that it had received. It was basically just an unremarkable business transaction involving a fairly discreet and insular group of brokers, all of whom knew that they were trafficking in questionable securities. But the defense attorney sort of started darkly hinting that there was going to be something more spectacular about his defense. His theory of innocence was something that he was going to ultimately sort of show was far more interesting than it might first have appeared. He sort of alluded to the features of this case that will develop absurdities which tower up to the sublime. He sort of proceeded to do a kind of a survey of the defendant's life history, starting from an early age. He showed him to be someone who had respectable parentage, yet he had displayed from an early age very strange and strangely destructive behavior, destroying property without any apparent motive, and proving impervious to all forms of correction, even the most severe corporal punishment. As Huntington matured, according to the defense attorney, and turned broker, he moved his field of operation from upstate New York to Manhattan. The singular error of his mind continued to manifest itself, and it was channeled into a series of fraudulent schemes, each one more spectacular in terms of failure than the last. They were all sort of absurd and ridiculous ventures that he pursued. But yet he was this person who could always obtain funds because he had an easy, pleasant, quiet, plausible, winning way with him, which was well calculated to lull inquiry. The exercise of due diligence would, however, have sort of tipped anyone off if they had been proceeding with care. And anyone also could see that what these different kinds of projects that he was pursuing really did exhibit ultimately was a morbidly erratic intellect. Most striking of all about Huntington's behavior, the defense attorney said, was its self-destructiveness. Brazenly forging notes without any attempt at imitation, he acted as if he was doing nothing wrong and ran no risk of bringing, ruin and disgrace upon himself and his family. From the time of his arrest to the present moment, he refused to participate in his own defense. His lawyer noted he oddly remained cheerful and confident that he will not be pursued, and he believed that the jurors would ultimately conclude that he was neither knave nor fool. It was this complete want of moral sense that gradually led the Huntington defense team to credit stray remarks about his insanity made not only by the likes of the prosecutor in his opening, but a host of business associates and family members who used words like mad and crazy to describe his conduct. Although they might have been speaking in a merely conventional and not legal sense, the attorney conceded, they decided to put the question to a number of doctors who engaged in personal examinations of the defendant while he was in jail. And they concluded from these observations and examinations that he was indeed clearly someone who could not be any more accountable for his behavior than a child arrived at age of discretion. Accordingly, the defense team entered a plea of moral insanity, contending the defendant had what was described as a monomania for forgery. In doing so, they not only conceded that Huntington had forged the $6,500 promissory note that was the basis of the indictment, he also, the defense team also admitted this is but a small fraction of the money his client had made in this fashion, estimating that he had probably sort of forged notes that reached the staggering amount of $20 million, according to the defense attorney. So he embraced the idea that the forgeries that were before them were just the tip of the iceberg. Speaking with more zeal than the prosecutor, Huntington's attorney underscored the audacity of his financial exploits, though this was done ultimately to persuade the jury that no sane man would have behaved with such reckless abandon, that the defendant was impelled by what he described as an insane impulse to forge, his hand guided by a power he cannot resist, such that the forgeries were not his own. To substantiate his claim, he promised to call some of the most able and distinguished medical men in the country to the stand, but he chose to close his opening with an allusion to Shakespeare's Hamlet, likening Huntington to the Danish prince whose self-diagnosis was quoted by the attorney to exonerate his client. I won't read it all dramatically to you, but the crucial lines here are the last ones where it really isn't Hamlet who does it, but his madness. His madness is poor Hamlet's enemy. Just as Hamlet was not responsible for his deed, neither was Huntington. Now, this declaration caused an immediate sensation in the courtroom and seemed to have come as a shock to prosecutors who looked on with disgust as the defense attorney went on to note that they had been proceeding contrary to the consent of their client's own wishes and only after gaining the consent of the family. As if to confirm the truth of the counselor's proposition, the heretofore expressionless Huntington was heard to say, "A splendid farce, a capital joke, by God." The defense team would live to regret this rhetorical maneuver, although it sort of caused this rather spectacular amount of publicity and notice in the courtroom, because what the prosecution did in response ultimately was offer an alternative reading of the case of Hamlet, going to show that he was a simulated maniac. Who feigned disease in order to detect a great crime, to expose his father's murder. Huntington and his lawyers suffered by comparison because they were falsely pleading insanity to cover the greatest crime known in a commercial community. The defense the medical witnesses hardly came off any better because they were cast as dupes who failed to appreciate this Huntington character was clearly only playing the part of the madman. Now, you may wonder here whether it would have been a good idea to summon up passages from Shakespeare as a good trial strategy, but I will just quickly note that there is a huge amount of disputation between doctors and lawyers in this period about whether Hamlet was actually insane or not. Lawyers tended to think he was feigning, and doctors in this period who are just coming into their own and sort of they have patients that they can mobilize, say they have lots of Hamlets in their asylums who are feigning insanity but actually have some other kind of mental disorder. But there are extensive disputations about this and textual analysis that are very interesting to see. What I want to focus on for purposes of for this lecture is simply that the trial of Huntington was one of the first times that moral insanity, let alone Hamlet, were brought to the fore as means of exculpating forgers or any kind of criminal for that matter. And so it was a testing ground for that particular doctrine. And in this particular instance, it didn't get them very far. When it came time to charge the jury, the judge ultimately just hewed very closely to the McNaughton test of insanity, which is a cognitive test, the capacity to know right from wrong. The fact that you are morally insane is just defined away from consideration of the jury, which returned a verdict of guilty, and Huntington was sent to Sing Sing for the maximum term of 5 years, and the community celebrated that this was a sort of beginning of taking fraud seriously and also giving quietus to this crazy defense of moral insanity. The great forger ever after became synonymous with the insanity dodge, and the best that the losing party could hope for was to try to renovate their character a little bit by they published the entire transcript of the trial, as well as a appendix that included sort of a lot of more cases from asylums that showed that people like Hamlet were indeed insane. Huntington himself served his time, ultimately becoming a productive woodworker, doing the books for the prison, interestingly. Warden, upon release from Sing Sing in 1862, several of his creditors obtained a judgment against him, and an order of arrest was granted, which landed him in the Westchester County Jail. He petitioned for discharge under the New York insolvency laws, but the court abstained objection to this, and so Huntington had a status as an unpardoned felon who was incompetent to sort of seek release in this particular way. Out of the frying pan and into the fire, read the last news report of his whereabouts. We don't quite know what happened to him or all of that money for that matter. What we do know is that this forger had many imitators, and these confidence men who seem to be appearing in more and more numbers. But what was most interesting and I think troubling in this period after Huntington was the extent to which small-time operators were being apprehended and punished in various ways, but the bigger operators were escaping criminal prosecution. And indeed, one might think of Huntington, too, as the one that sort of took the fall for lots of other more sophisticated brokers who were escaping criminal prosecution. And that is where I'm focusing my attention as I proceed with this project, and later chapters of the book explore and try to make sense of what does and doesn't get prosecuted, what kinds of financial crimes do seem to be worthy of prosecution, and the different penalties levels that attach to them. And here I'll just sort of point to some interesting characters that are on the horizon here. This shows you the kind of ways in which they both celebrate and excoriate these financial characters and other kinds of fraudsters. Thomas Lawson, very briefly, is a stock jobber turned muckraker turned fraudster anew. He first makes a killing in the stock market by manipulating it, then is excoriated in the press, and then decides to sort of become a reformer. He has an axe here because he says Teddy Roosevelt's big stick is not big enough for the fraudsters he's after. He eventually, so he publishes this book as a sort of piece of muckraking journalism, and then either tires of it or was never really all that committed and writes Friday the 13th, which is a novel that actually causes a financial panic, which he then profits from. So he's pretty ingenious. But I don't want to leave you only with fraudsters, because the point of my book is really to show the apprehension of fraud. And so I want to mention, by way of conclusion here, George Alger, who is a progressive lawyer at the turn of the 20th century, who is not really, he's not a fan of fraudsters, he's not a fan of muckrakers either, because he thinks that they're exaggerating the problem in ways that just produce moral overstrain, and people are no longer shocked by what he describes as the modern business vampire. And so he pursues a different set of strategies, including all sorts of different kinds of investigative commissions that I write about in that part of the book, that are designed to call attention to both the importance but also the difficulty of prosecuting intellectual crime. And he talks about how modern civilization gives us sort of safety from physical danger, the murders and other kinds of physical assaults that barbaric societies have to endure. We no longer have to endure because we are civilized, but we have a new form of crime, and that is intellectual crime. And we need to recognize that as a public threat in and of itself. And what intrigues me ultimately, and what I'm spending a lot of time thinking about, is why it is that intellectual crime is so difficult for us to think about as crime, the ways in which we tend to think of that as just using your intelligence in ways that you profit from, and when and whether we consider taking advantage of your mental acuity as a crime is something that I think we have a difficult time apprehending well into the present. So what I really want to close by saying simply here is that what I hope to at least have started to show and intended to show more fully in the book is that the laxity of law in the 19th century is greatly exaggerated. There needs to be a lot more attention to the ways in which the law is working, maybe not always successfully, but in many ways to regulate and bound sort of behavior that is considered to be legitimate and behavior that is considered to be illegitimate in all sorts of settings, both in the market and outside of it. But what I ultimately want to try to understand is why certain kinds of fraud, especially when it sounds in sort of some sort of intellectual kind of wizardry, becomes difficult for us to comprehend as crime. To show you that this is a problem that's very much still with us, I will just leave you with a couple of images that will be somewhat familiar to you. We have, of course, Bernie Madoff and Bernie Madoff, The Big Short, which is a true story. And here I'm slightly obsessed at the moment with Elizabeth Holmes and her debacle that is Theranos, to say, for those of you who don't know, a Silicon Valley venture that has been shown to be fraudulent at core, or well, she still hasn't conceded that completely. But what I'm interested in is the fact that she, in the latest documentary, is in fact figured as someone who might be crazy. She also says, first they say you're crazy, then they fight you, and then all of a sudden you change the world. So there is this kind of interesting way in which fraud is something that we both laugh at, find absolutely intolerable and sort of immoral in the extreme, and also can imagine is something that is just outside the boundaries of the rational and therefore responsible. And I think that sort of set of reactions that don't always altogether go together, I think is very revealing. But what I mostly want to say by way of conclusion here, as I look at these characters and think about Huntington, is that I can't help but sort of call to mind Karl Marx's sort of notion of how and the way in which history repeats itself, that all great world historical facts and personages appear, so to speak, twice, first as tragedy and second as farce. I think actually they do both in the story that I'm telling constantly. I think there's something about the history of fraud that is really tragic comic. That being said, I will basically conclude by saying simply that I can't help but feeling optimistic, despite the fact that the story I've told isn't particularly hopeful. It's something that I'd like to think is my choice. It's probably hereditary. It probably doesn't come from reading history, but it does come from teaching and working with all of you here at the University of Minnesota. I feel incredibly happy to be able to celebrate this occasion with all of you. I think we have time for questions, if there are any.
I have a question. I'm glad you're giving this lecture now when you're not done with your book because you missed the biggest fraudulent event in the state's history. And that's John D. Rockefeller and my family on the North Shore. And,
Wait, what about your family?
What I would like to start out as a question. How are you going to police people like that? For example, after the discovery by my family back in November of 1890 up at Mountain Iron, they developed the railroad and the dock in Duluth, and they started mining. And then they got entangled with John D. Rockefeller, the biggest robber baron around. And he stole the whole thing from the Merritts. My grandfather, Alfred Merritt, sued Rockefeller in federal court up in Duluth. It was a 9-day jury trial, and the jury came in with a verdict in favor of my family. And Rockefeller, of course, used to brag he never lost in the courts of appeal. So he took it to St. Louis to the 8th Circuit, got it reversed and remanded. A lot of historians don't know the difference between a reversal and a remand. But my family could not afford another trial, so they settled. And they didn't know during the trial with Duluth lawyers, some of them were not the greatest, that Rockefeller had put into the combined Lake Superior Consolidated Iron Mining Company with my grandfather and his brothers, mines over in Michigan and Cuba that were worthless. And there was a letter discovered by the Allen Nivens people at Columbia University many years ago, 50. And then it was discovered later by Ron Chernow, who wrote the book Titan. And the letter says basically from Rockefeller's chief emissary out here, Frederick T. Gates, that the properties Rockefeller put in the mine, in the Consolidated, were worthless. That letter never appeared. And yet we had discovery, we had requested for production of documents in 1895. So what are you going to do about that? How are you going to police that? I'd like to know.
It's a great
And
question.
I have a book, I've written this up if you want to read about it.
We will need to talk for sure. This is Rockefeller right here, and I am on his trail a little bit, but I take your larger point, which is, I think, and it's something that I think continues to be true, the ways in which litigation itself can be sort of devastating to the victims of fraud because it's so difficult to, I mean, the expenses that are involved constantly, I think, sort of are prohibitive for people that, I mean, there are people that lump it because they don't want to sort of show themselves to be duped, and there are people that lump it because they simply can't afford it. And so legal processes, I think, can be their own form of harm, independent of the fraudsters themselves. And so I take your point. Thank you. It's an important one.
Two quick questions, one legal and one cultural. The legal one is you mentioned that P.T. Barnum is trying to get to a clear definition of what fraud is, and the courts are not completely there. How does that sit with, at least following Horowitz on this, the tradition of going into greater categorization of the law and clear categories and classification of everything? So it would seem that you would need to go to a clearer definition of fraud, and that's not the story, at least that one tells. The second one, with respect to culture, and goes to the question of why it is that it might be difficult for some acts of fraud to be perceived as such. So I'm wondering, as I'm listening to you, to what extent is the fraudster, or some fraudsters and some humbuggers, seen as some sort of the modern, at that time, modern frontier?
Well, so to your first question, that is exactly sort of, that's an aspect of my critique of Horowitz, right? That the kind of way that we understand 19th century jurisprudence is moving towards categorizations, formalism in various ways. And again, I think at least these judges and treatise writers are reserving the right to not be that sort of scientific about the law. They're not moving into those kinds of forms of categorizing, or fraud resists that kind of bounding. And that's all I can really say to that, which is that I just think it's an interesting fact that that's not the case. And the play and the law is something that is, I think, also part and parcel of an adversarial culture. And that's an important thing to sort of emphasize as well. Again, when you look at the level of doctrine, you don't always pay attention to the way trials play out. And it is obvious in these kinds of, it was obvious in the insanity trials I looked at, and it's even more obvious in these fraud trials. These lawyers are doing some things that they know to be really more than stretching the truth. And it's funny. People laugh in courtrooms because of the preposterous nature of the claims that are made in either direction. And so there's something about the way the legal culture celebrates its own forms of swindling that I think are on the face of these fraud trials in a pretty vivid way that I'm just basically very interested in. With respect to the larger cultural piece of it, the idea that there are, can you say a little bit more, the idea that there are,
So these are kind of the new entrepreneurs, they're the ones who are thinking outside the box, they're the ones who are pushing the limits, so they should actually be, to some extent, applauded rather than anything else.
Well, that is certainly part of the caveat emptor storyline. And it's not that caveat emptor does not exist as a thing in the 19th century. Sure, it does. But there's two sides to the argument, right? And while there are certainly arguments being made that this is creative destruction, right? Just like, we have to have a new bridge, the Charles River Bridge, because, otherwise we're just going to be living in a world of horse and buggies. We need to sort of always encourage new technological developments or other ideas, creative ideas of all sorts. And with that comes a certain amount of destruction. What's clear, however, is that that's not tolerated to the exclusion of other values. And what is very interesting to me is the ways in which what's very vividly recognized also in the law is the kinds of betrayals of trust and the harms that those affect on the business community, quite apart from other realms of American life. Within business, there's a need for trust at its core. And that's why you can have a prosecutor come up in the Huntington trial and just talk about, he says at one point, this defendant has stabbed the soul of this commercial society by virtue of his deceptions. And so this is serious business, or at least it's presented to be in court, and that cuts against the sort of just brazen celebration or celebration of brazenness that you see certainly in some other sectors of the culture. Thank you.